We will centrally prescribe a list of non-taxable government fees. Fees in a non-taxable list would include those for applications to confer approval for the conduct of a regulated activity. For example, applications for professional licenses and their license renewal fees will be non-taxable, as they confer applicants the right to practice in the regulated profession. This would also include the 18 regulatory fees that we are refunding. All other fees that are not part of this list will be subject to GST. As part of this change in legislative approach, moving forward, MOF and IRAS will henceforth work closely with agencies to assess their fees instead of allowing self-assessment by agencies. MOF had earlier reviewed all the regulatory and ancillary fees that currently charge GST and announced in February the refund of GST on 18 fees where GST was wrongly charged. We are now working with agencies on the remaining regulatory and ancillary fees which do not charge GST. There are in total more than 1,700 such government fees which MOF is in the midst of reviewing. All fees that are not prescribed in the non-taxable list will be subject to GST. There are three categories of such fees. The first category, which is the vast majority of fees, comprises fees for services provided by the government which are clearly subject to GST and are already charged with GST today. There is no change in the treatment of these fees. The second category comprises fees that are charged with GST today, but where there has been inconsistency in the interpretation of the law by agencies. The charging of GST on these fees is in line with our clarified policy intent, but is susceptible to legal challenge under the current GST Act. Hence, for agencies that have been charging GST on such fees, we will validate these past GST collections should they not have been made in accordance with the current GST Act to ensure consistency between the legal position and the clarified policy intent, which is to subject these fees to GST. For these two categories of fees, there is no change to the status quo. These fees are already charged with GST today and will continue to be charged with GST. The third category are fees that are not charged with GST today, but should be charged with GST moving forward, based on our clarified policy intent. These include examination fees, which some agencies are currently not charging GST. Other examples include inspection fees prior to the licensing and conduct of certain business operations. We estimate that there are more than 100 such examination and inspection-related fees. For this third category of fees where GST has to be charged, the government will help to minimize the impact on the public. We will absorb the GST on these fees in the first instance and impose a freeze on these fees until end 2025. Hence, all affected fees will not increase immediately as a result of the amendments.